Streamline the contract, just like your Icon aircraft is streamlined. Design your contract like you design your aircraft, and you'll have less deal fatigue. You'll sell more airplanes. The owners will be pleased.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, corporate attorney Chad Busk breaks down the purchase agreement and operating agreement for Icon Aircraft's A5 plane. He digs into the relationship between the purchasing and operating agreements and explains why companies might take on more liability than you might expect. Chad also makes a demand that your contract language be as streamlined as Icon's aircraft. So, let's tear it down. Hey everybody, welcome back to the Contract Teardown Show. I'm Mike Whalen. In this show, we talk to really smart friends like Chad Busk over here about contracts. We tear them down, we break them down, we get a little nerdy. Chad, how are you today?
I'm doing well, sir. Thanks for having me on your show.
Is it cold up there yet? Chad is in Michigan. Just as a side note, I was accepted to Michigan for law school. They called me and said, "You're in Austin. Are you just going to go to Texas?" I said, "I'll tell you what, what's the temperature right now?" The lady said 17 degrees. I said, "I'm going to Texas." Are you cold yet?
Well, we're fairly cold, right? But we haven't had snow yet, but it's probably due in the next week or so.
It's early. So guys, Chad has some experience in a really interesting industry, and that has led us to talk about these documents. I'm going to share them with you real quick. This is an aircraft purchase agreement and also an operating agreement with a company called Icon. So if you're in the business of buying airplanes, which it's been weeks since I've done that, Chad, you might run into these things. Chad, tell us about these documents. Why are they important? When would a lawyer run into them? Why should they pay attention to this teardown?
The Icon A5 is a light sport aircraft that is amphibious, and it's basically for the hobbyist with a lot of discretionary income.
Right.
You would buy this airplane, keep it in your garage, put it on a trailer, take it to a lake, or take it to an airport, and you could get into the aircraft and fly it to the lake or another airport in fair weather, in daytime, in warm weather, under 10,000 feet. And you maybe would go fishing after you land on the lake, and then you would do your business and have fun and do sporting things, and then you would fly home, fly back to your dock, put it on your trailer, take it back to your garage.
As you do.
The cost of the aircraft in 2019 was $389,000. So, and it's been called the jet ski with wings. So you have to have a lot of discretionary income, and you have to be quite adventurous to get a light sport aircraft pilot license in order to fly this thing safely. And in fact, Icon makes sure that whoever flies it is licensed to fly the aircraft to avoid liability. And there have been accidents with the aircraft. As near as I can determine, accidents have been due to pilot error and not to a design or production flaw in the aircraft itself. In one case, someone was flying the aircraft on a cocktail of prescription medicines, and they were definitely impaired, and they died as a result of crashing the aircraft into the water. But that as it may, this is the two documents that they want you to sign for you to buy this airplane.
So if you're like me and just fly around to go duck hunting because where we're going, we don't need roads, you want to learn about this agreement. But also, we're going to talk in the end about some of the general principles that you can pull from a purchase agreement and an operating agreement like this, because there's some really interesting principles in here. So, Chad, what we're going to do is I'm going to share some pieces of this document, and we're just going to go down through each of them. We're going to start with the purchase agreement, and I noticed early you had a beef with the word whereas, heretofore, therefore. Tell me about some of the archaic stuff that you're seeing here at the beginning of this agreement.
I always have a beef with those words, Mike. The Icon aircraft is a very sleek and beautifully designed aircraft, but the contracts they want you to sign for the purchase and operating of the aircraft, they're archaic. They're not sleek. They don't have good lines.
Right.
And it would put off a person wanting to buy the aircraft. And the first thing that that person would do is say, gee, with all these funny whereas and now therefore and in consideration of provisions, I better find an attorney and I better pay that attorney to go through these with a fine-tooth comb because I don't understand any of this.
Well, those
So if you
recitations at the beginning, like what's the purpose of all those whereases? Is there a place to put these kinds of things?
you don't need them.
Yeah.
You don't need them. You can just have a statement of facts. You just have a paragraph with no heading that just states what this agreement, why this agreement. Basically, Icon is in the business of selling aircraft.
Right.
The buyer is interested in buying an aircraft, and then you just go to the agreement. You don't need any of this stuff. This is archaic contract design, and it's redundant, and it puts off the reader.
Yeah, you mentioned even in the recitation of the consideration, saying that we've got good and valuable consideration. That feels like law school classy, but again, not necessary.
Just reciting consideration in a contract doesn't mean there's consideration. The court will look at that and determine if there is in fact consideration. Now here it's easy because you're buying an aircraft, you're exchanging money for an airplane. That's consideration right there. You don't need to say that there's consideration. It's obvious.
Hey everybody, I'm Mike Whalen. I hope you're enjoying this episode of the Contract Teardown Show. Real quick, I want to ask you to do me/you really a quick favor. Look down below. You'll see a discount code to join the Law Insider Premium subscription. When you do that, you get access to more content like this. You'll see webinars, daily tips on contract drafting, not to mention access to the world's largest database of sample contracts and clauses. It will help you write better contracts faster. If you want to do it right now, there's a code below, so get there. Also, if you're part of a larger team, if you're in-house or in a law firm, just email us. We're at sales@lawinsider.com. We'll make sure you get a deal as well. Come join us in the community. The code is below. Let's get back to the show. Well, I'm going to scroll down, Chad, and what we're going to do, guys, is jump from the purchase agreement to the operating agreement here in a minute because they have such a tight relationship. But I'm jumping down to this operating area. It's in 5 of the purchase agreement, and a really interesting section about paying an additional $10,000 to purchase the agreement has to do with some of these indemnifications. Tell me about this section. It's really interesting.
It is interesting, and I don't understand the reason behind it. Basically, they have very one-sided covenant not to sue and indemnity provisions, but you can get rid of those, not agree to them, if you pay an extra $10,000 on top of the purchase price. But that's only 3% more than the purchase price. So my point is, just don't charge an extra premium. Just add that onto the purchase price and don't have those complicated provisions in the contract from the get-go.
Right.
Make it easier to do the deal and to sell an airplane to someone.
Yeah, and I'm thinking of, as a theme, we're going to see a lot that the airline, that the company Icon is sort of risking a lot to sell this thing. I'm thinking of this closing window underneath in 6A. It talks about the estimated closing date can be moved by Icon if Icon changes the moving date. I'm assuming that when you buy a plane like this, there's a certain amount of build to suit, right? That it's not just sitting in a showroom somewhere. Maybe that's why they're trying to do this, where they get to control sort of the production timeline, maybe?
I'm sure they want to control that. You can buy the basic vanilla version, but you can add bells and whistles for an extra charge. But they get to delay closing. You have no right to delay the closing. And to me, again, that shows that it's one-sided. But if you want to buy one of the airplanes, you can't go anywhere else and buy it from somebody else. So basically, they have the bargaining chips on their table. On the other hand, if they want to do a deal and avoid what I call deal fatigue, you're going to have a contract that's easy to grasp so you can get on with the show.
Yeah. Yeah, and going down to 6E, I mean, again, it's talking about this, how little power the buyer has. Following buyer's inspection and during the closing window, buyer must provide written notice to Icon of any items buyer believes do not conform to Icon's internal quality specifications. And if you don't give that notice, you're accepting the aircraft as is. Again, trying to put a lot of onus on the buyer to not undo the purchase.
but you don't know. A buyer doesn't know what Icon's internal quality specifications are. They can be anything that Icon says they are. And furthermore, they're going to be hidden. And if you're just an ordinary Joe or Jill with a lot of money, you're not going to be qualified to go into that aircraft and say, yep, it conforms to their internal quality specifications.
Right.
Again, it shows they have all the chips on their side of the table.
Yeah, and I'm looking down at 8F specifically, where they really nail this home. They say Icon may terminate this purchase agreement at any time for convenience. Again, giving them a lot of control over that production schedule.
That's true.
I'm moving down now. There's quite a large section limiting, a limited warranty and a disclaimer of warranties. Jump down to that. That's in section 11, and talk to me about this area. What are you seeing? I see a lot of bold, a lot of capital letters. Do you like this section?
They're trying to make it conspicuous, and they're putting it in all caps and bold. But under the Uniform Commercial Code, to make something conspicuous to satisfy the code, you don't have to put it in bold and in caps. If they kept the font in bold, that would do it. Putting something in all caps, again, hurts the readability and comprehension of the contract. It just makes it harder to grasp, and there's no reason to put it in caps. It's like shouting. It's like the email shouting. You don't need to do it. Uniform Commercial Code doesn't require it, so why do it? Just because attorneys have been doing it for years, and they go ahead and do it just because that's how they've been taught when they're in law school or when they were in a law firm. Hey, this is disclaimer language. We better keep it in bold. We better put it in all caps. But it doesn't fly. It doesn't fly with me. I guess that's a pun. It doesn't fly.
So, well, speaking of sort of these things that are meant to nudge the buyer, I'm interested. We're about to talk about the other agreement on operating this thing. Under 13, they talk about operational safety already, and there's an interesting bit about the sort of what you're buying into. Talk to me about this area that sort of hammers home, this is what you're getting into if you buy this plane.
Well, that really goes to the operating agreement. You are buying not the airplane, you're buying the airplane, plus you're going to do everything that they want you to do for the life of the airplane, as long as you own it.
Right.
And that's where we get into the operating agreement, not only signed by the buyer, future owner of the aircraft, but also the managing pilot. The managing pilot must be a person, a natural person, an individual who is qualified and licensed to fly the airplane. The managing pilot may be different than the owner, but ICON will always know the identity of the managing pilot and be able to track him or her as they remain qualified to operate the aircraft over the life of the aircraft. And I have an interesting point on the management pilot. I understand that there's consideration between the buyer and ICON when the buyer purchases the aircraft, okay? But what consideration is to make a valid agreement between the managing pilot and ICON? I don't think there's consideration. They can say there is, and they do in the operating agreement, but I don't think there's consideration between the managing pilot and ICON.
Yeah.
To me, that's a problem, and I don't think that they've addressed that properly.
Yeah, we'll show you guys that because there is a whereas. So theoretically, it's happened. I'm curious, sort of in principle, a theme that we've seen throughout these interviews, throughout these teardowns, Chad, is that the contract sort of has two purposes or two functions. One is that it makes clear what's being agreed to, and two is that it sort of nudges people. It encourages them to recognize things, to say, hey, this is happening. I'm looking at this section about how often you're doing engine overhauls and parachute repacks and recovery, rocket replacement, all these different things. Does reciting these things here have any kind of legal effect in this document in terms of, hey, you can't get out of this deal because this stuff happened because we told you that was coming? Or is this mostly intended to say, hey, dude, you're getting into a big deal here?
I think it's both, actually. I think they're trying to reduce their liability by telling the owner what they have to do to maintain the aircraft, and they talk about the operating costs of the aircraft, both fixed and hourly costs. on their website, they put specific dollar amounts for both the fixed and the operating costs. And I suggested they link to their website in the operating agreement when it talks about the things you have to do to maintain the aircraft. Why not link to the website that has the actual costs so that somebody can see what they're going to be stuck with to maintain and operate the aircraft properly over the life of the aircraft?
Yeah, we're about to jump to the operating agreement. Before we do that, guys, this bit is fascinating. I know what a black box is because I watch TV. That's legitimately the only reason. But they point out in 15, notwithstanding anything to the contrary herein, the flight data recorder and the data collected is and remains after the closing of this sale the sole property of Icon. That's fascinating. Tell me about that.
Well, they do that because if the aircraft is involved in a crash, then they can retrieve the flight data recorder and they can find out what the pilot was doing or not doing when things went wrong. And in fact, in some of the crashes, you can get on a website and they have an analysis. The FAA did an analysis of what happened to result in the crash, and you can see data directly from the flight data recorder that's on, I think it's the FAA's website. So that, again, the Icon can say, well, this is pilot error. Our aircraft was performing fine, but whatever joker was operating it, did this, did that. They flew the aircraft outside of its performance parameters, and then they crashed. So, hey, that's that. We're sorry it happened, but we're not liable for that, according to the flight data recorder data. See ya,
So, speaking of, you drowned your plane and ran into the ground. We're going to jump over to the operating agreement. I want to get you to sort of give me the big principle here. When you've got both a purchase agreement and an operating agreement, especially when you've got a big purchase like this, what's the relationship between those two? Do you even need an operating agreement to get the sale completed?
I think the reason why they have an operating agreement, Mike, is because managing pilot is a party to the operating agreement. They want to tie in who's ever going to fly that plane, and that person may be different than the owner. That's why they have two agreements and why you really can't combine the two, because managing pilot doesn't sign the purchase agreement. He or she signs the operating agreement.
Yeah, and to your earlier point, there is this whereas the parties acknowledge, et cetera, that this deal was arrived at in consideration of the provisions of this operating agreement, specifically including but not limited to the agreements and waivers of owner and managing pilot and the indemnifications herein.
I don't see how managing pilot can waive anything because there's no consideration for him or her to do so. So I think they have a problem, as I've said before, with that.
Yeah, and on that, if you jump down to 1F, it's talking about the importance of this relationship with a managing pilot. It says that the owner agrees that the aircraft will not be flown if there's no managing pilot. It's grounded, and it talks about this vacancy in the managing pilot position due to resignation. Talk to me about this section.
Well, I think it goes on to say that Icon must always know who the managing pilot is, so that they know that that aircraft is being flown only by managing pilot who's authorized and licensed to fly the airplane. Again, they don't want some person that's not qualified to fly that aircraft, because if that happens, then they might be liable. So they're trying to control the operation of the aircraft from cradle to grave or over the useful life of the aircraft, so that they don't have any liability, so that they can't be sued, or if they're sued, they'll win. Actually, there's a mandatory arbitration clause, so we'd have to go to arbitration.
But does this create a continued, what would make me nervous about this is creating a continued responsibility for the manufacturer that's really not true in any, in most purchases of commodities like this. Why would this company agree to do that, even if it creates this management responsibility ongoing?
It is. You have to track all your contracts, your operating agreements very carefully. It would be a challenge for accurate contract administration to do that. Right. But they not only have liability exposure, they have reputational damage. So if there are these crashes of their Icon A5 airplanes in the industry, in the aircraft industry and elsewhere, they're going to develop a bad reputation. So why would anyone want to buy an airplane this expensive that might crash? So they want to protect themselves from not only liability, but also from reputational damage for flying these aircraft around.
That's an interesting one, right? Like we tend as lawyers to say, I want to avoid liability to my client, but here is a client saying, no, we would rather have that liability, that responsibility ongoing than, there's a business trade-off in there, and they're consciously apparently making that trade-off decision.
I think so. I don't know how well they were doing. I know they had a little financial difficulties a few years ago, but maybe they've surmounted those. So we'll see.
So I'm jumping down now, getting back to this thing about the releases of liability and the managing pilot. And here in 4, there's a section called Optional Release and Covenant Not to Sue, Limitation of Liability. These are selections, extra selections that both the owner and managing pilot, I assume, make together, that you can't choose these things unless they both sign. Talk to me about this optional release section. I think you might have mentioned it. Is this the $10,000 deal you mentioned in the earlier agreement?
If you pay an extra $10,000, those go away. Again, why have this awkward $10,000 premium? Just build that into the cost of the airplane, and just don't have those provisions in there anyway. The first thing someone is going to do if they have any smarts at all, if you have enough money to buy an airplane, you have enough money to hire an attorney to look at those provisions and say, you shouldn't agree to those. You shouldn't agree to those. And they still have an indemnity later on in the operating agreement. Indemnity if the owner managing pilot breaches the agreement, they've got an indemnity for that too. I wonder if before you agree to that, if you should contact your friendly insurance broker and see if you can get insurance, maybe in the way of an excess liability policy that would insure over that contractual indemnity obligation. Otherwise, the buyer and managing pilot, assume it sticks to the managing pilot, as I said, their assets are going to be exposed on that indemnity. And you don't know what that liability is. So they may want to investigate insurance coverage for that.
Yeah, and on this election, what's interesting to your point earlier about this relationship between the owner and managing pilot, which could be two different people and maybe often are two different people, but it's got a place for both of their signatures on their initials on these individual sections. So like if the owner doesn't want to pay the 10 grand for whatever reason, I don't know why they wouldn't, but the managing pilot is saying, no, I'm not touching this thing. It's interesting that they both have to be on the same page, even in making this election.
Sure. And you wonder then about what type of an agreement a managing pilot should have with the owner, right, if they're separate. If I represent a managing pilot who says, look, I'm going to fly this airplane for this gentleman or lady who's the owner, I want to make sure that I've got a contract between me, the managing pilot, and the owner to protect me vis-a-vis the icon. So there's that to consider too. This can be a tangled web before we reach the end of the road here.
And getting below in 4E, and it sort of lists out these different kinds of indemnifications that can be purchased. But then, like you pointed out, in 5, there's another different section that is apparently a non-purchasable, waiver of claims or whatever. Talk to me about 5A, this other indemnification section.
Well, I think the other indemnification, I can refresh my recollection real quick, but I think that has to do for breach of the contract.
Yeah, it talks about against any claims, actions, suits, proceedings, losses, damages, etc., to the extent that losses are caused by or a result of any breach of the representations or warranties in the agreement.
Broad indemnity, which I just mentioned, maybe should be insured over if you can get insurance for that type of indemnity coverage. I don't know.
So just a couple more here, guys. I want to talk about the definitions in 7. There's a section called definitions, and again, a theme in these conversations that we've had is where those go. Should they be contextual? Should they be at the beginning in bright lights? What do you think about the definitions of these roles?
When I write contracts, I have a definition section, but I always move it toward the front of the agreement because I think it's more logical to put them there than the end. There are some plain English advocates, especially Ken Adams, who is the guru of plain English in these modern times.
Right.
He likes to define, doesn't usually go and recommend a separate definition section. He usually recommends contextual definitions. The first time you use a word in the contract, you capitalize it, and then that means it's a defined term for the rest of the agreement. So that's how I do definitions.
You like standing them out. So finally, I'm speaking of the cradle to the grave ownership for the manufacturer. I'm looking at 11. It talks about transfer of the aircraft or this agreement. It seems to limit your ability to go sell it without them buying onto the whole thing. Talk to me about this transfer section.
Again, they want to know who their aircraft winds up in the hands of. Right. So they have to control and be aware of any sale down the road of the aircraft to make sure, again, that whoever has it, if they're not authorized to fly it, they have a managing pilot that is trained and licensed to fly it. So they track that aircraft through its useful life. Because, again, avoiding liability exposure, avoiding reputational damage,
right.
They can control it.
Yeah, when you're selling a $400,000 toy, you want to make sure that the kids are playing with it correctly. So I'm thinking, Chad, this is a really interesting document. Obviously, a lot of the people watching this may not be buying and selling aircrafts. If you want to, I guess you could buy one for me and I can give it a shot. I'll be your test dummy.
Well, Mike, you can fly the Icon aircraft if you have Microsoft Flight Simulator 2020 and a powerful enough PC to run it. You get the Icon aircraft here free of charge, included in your library of airplanes that you get when you buy Microsoft Flight Simulator 2020. Yeah. So I flew the airplane in that program, and it's fun.
And then I don't have to go outside, which is a win-win. But Chad, I am curious. In terms of principles, like what are you seeing as take-home principles that somebody who's dealing with the purchase agreement or maybe the purchase of a large product like this, what kind of principles can you give to drafting attorneys from this example?
I would make it more simple. I would avoid archaic contract language. I would avoid needless liability provisions and build extra liability into the cost of the aircraft, as I said. Don't have things in bold, caps. Streamline the contract, just like your Icon aircraft is streamlined. Design your contract like you design your aircraft, and you'll have less deal fatigue. You'll sell more airplanes. The owners will be pleased. That's basically what I recommend.
Put your contract in an air tunnel. You'll win every time. Chad, if people want to get in touch with you to talk more about purchasing flying things or other subjects, what's the best way to reach out to you?
I have a website that's busklaw.com, and my email address is busklaw, one word, @charter.net.
Awesome. Well, I appreciate that, Chad. Thanks for being with us. And all of you watching can go to the show notes of this episode by going to lawinsider.com/resources. Also, if you want to be one of my smart friends and contribute, just send us an email at community@lawinsider.com. We'll hang out. We'll see you guys next time. Thanks again, Chad.
Okay. Thank you, Mike. Appreciate it.